Good afternoon. We're going to call this meeting to order at 1:01 p.m. Thank you for attending. This is the Bylaws and Resolutions Advisory Committee meeting of Ocean Pines Association. Today is January 12th of 2024. So happy New Year, everybody. This is our first 2024 meeting. We called the meeting to order. We do have a quorum. So I will ask my committee members present that, as always, we always give consent or vote to have our meeting recorded. Is anyone opposed to having the meeting recorded?
Nope.
Okay, thank you very much. And then we always post our recorded meetings on the website when they are able to get them posted. So we'll introduce our committee members. My name is Laura Pangratz, and I am the chairperson for the Bylaws Committee. And I am a full-time resident here. I've been full-time for 2 years. We've had our home for 9.5. So would my other committee members introduce themselves, please?
Keith Kaiser, permanent resident since 2014.
Augie Flengy, vote here since 2014, part-time.
Thank you. And our other committee member, Pam, hopefully will join us when she can. I know she's out of town, so she may not be able to join virtually. I would also like to introduce our board liaison. Would you introduce yourself, please?
Steve Jacobs, board liaison.
Thank you.
Good job.
And then we always introduce our guests here. So would my guests please introduce themselves?
Which way was Bob Hilligus, former board member or committee member, excuse me, that's right, resident property owner since 1998.
So,
I'm Jim Trommel. I'm now in my 22nd year as a full-time resident. And like Bob, I'm also a former committee member.
thank you very much.
I'm John Dilworth. I'm chairman of the Architectural Review Committee. Bought our house here in 2003, moved permanently in 2014.
Wonderful. Thank you very much. As you can see up on the screen, I do have our agenda. It was slightly amended from the last one that I sent you, because I've had to update it twice. I added one topic under new business, and it's really a short question kind of thing that we're going to clarify. Is there anything that needs to be added to the agenda?
Looks good to me.
You're good? Okay. All right, so hearing no objections or amendments to the agenda is approved. So next up for business, we always approve the minutes from our prior meeting. So here are our minutes from the December 8th meeting that we have. Let's see if I can make it my committee members, please let me know if is there anything that needs to be updated or corrected, you know, like a typo or anything like that.
See a typo.
Is there anything else? Any corrections?
Oh, I see one typo, but I will fix it when I send you the final.
Okay.
It says an E under the. It should just say under the.
Okay. So hearing no corrections or amendments to the minutes as presented, we will approve them. Okay. To the agenda. All right, so next up, approval of minutes is public comment. At this time, would any of our guests like to make a public comment?
Laura, I would like to make a couple of comments.
Okay,
Okay, I have comments, one for the art guidelines and in particular the political signs provisions in the guidelines. And my second, I wish to make a couple of comments on the proposed draft of M06. With regard to the political signs, there was a meeting of the Board of Directors in May of 2014, which of course is now almost 10 years ago, in which the topic of political signs restrictions came up or was addressed. And the association council was present for the meeting and for the this discussion. The meeting was also included a general discussion of property restrictions and the enforcement and the processes for enforcement, but there was a separate discussion, approximately a half-hour length near the end of the meeting, that was solely on political signs restrictions and the art guidelines. The minutes of the meeting cannot now be seen on the association website. The posted minutes do not go that far back. However, you can see on one of the local social media forums, the entire video of the meeting is still remains posted. To sum it up, the Association Council advised the board that restrictions in there was no authority for the association to enforce restrictions in the guidelines related to such things as the number of signs that could be posted, the signs size that could be posted, and that kind of restriction. And those restrictions existed in the guidelines at that time. Subsequent to that meeting, nothing occurred. In the following years, until we got to 2020, literally 4 years ago from right now, revisions to the guidelines were before the board. And at that time, this committee, bylaws and resolutions, whether we call it a reminder or whatever term you want to apply to it, this committee communicated to the board in an email the substance of that 2014 meeting in the discussion with the council and the advice of the council regarding political sign restrictions in the guidelines. That email, in full disclosure, if I can put it this way, at that time I was the chairman of the committee, and the email that went out came from me to the board of directors email address. Copies went to the then members of the committee as well as to the general manager. And that was an action on the behalf of the committee. It was not a personal action by myself, although it came out on my own email address. Nothing transpired in the 2020 version approved of the art guidelines. And those are the red line guidelines that are now proposed. And the current red line does not make any substantive changes in such things as the number of signs that can be posted, nor does it make any changes in the limitation on the size of the sign. The situation is basically the same as it was 2014, but 10 years ago. I know of no other verbal or written advice to the board of directors regarding the guidelines provisions, other than what was given in 2014. Whether or not those guidelines have been superseded by some other advice for one of the councils since then, including the current council. I have no knowledge of it. Let's put it that way. And I believe that it is appropriate to comment on that, to bring this up again. What is the authority for the political sign guideline restrictions that are in the proposed and current ARC guidelines? In addition to that question on the enforceability, there is also a change proposed with regard to political signs, and that deals with the time interval over which such signage can be maintained on a member's lot. The guidelines as they are currently written have somewhat of an open-ended interpretation of when a political sign for a candidate, for example, can be put up. And the proposal incorporates the 30-day prior limitation as expressed in the homeowners association provision. And that's all well and good. I don't have any problem with that. But what I do want to caution is the interpretation of the start date, that the reference date for the 30 days is not what we traditionally or commonly refer to as election day. That one day in this coming November, where there is a one-day election, in-person election. We have now early voting, and we also have mail-in voting. Well, early voting, the start date for early voting can be determined well in advance because it's a code provision. You can determine when early voting starts for any given election from now until whenever you want to do it, out into eternity, at least until the legislature changes the early voting dates. That's not the case with mail-in voting, and I mention that only so that I recognize that. The main point I want to make is that the 30-day provision does not date from what we generally refer to as election day, or traditionally refer to as election day. The other comment I want to make is that in the meeting 10 years ago, the attorney made discussion was included internal OPA voting, director elections, referendum voting, and there are no such restrictions on Ocean Pines regarding those events. Ocean Pines can put in whatever restrictions. They'd have to, I'm sure, reasonable restrictions, yes. But Ocean Pines can put its own voting restrictions, its own voting event restrictions in the guidelines. And that does not exist, and I think it should be considered. In particular, let's go back to time. A number of years ago, maybe 15 years ago, there were objections to director election signs being put up too early. And a decision was made, well, we're going to do it June 1st, and the Elections Committee, when it has its candidate briefing, can pass these restrictions on to the candidates. I don't know what's being done in that regard now. Is time considered in those MO6 calls for signage to be covered in what I'll refer to as the briefing meeting? I don't know if the signs be covered in that briefing. I don't know whether time is restrictions are considered or not. Well, the Elections Committee does not have authority to issue such restrictions, and restrictions issued in that manner aren't enforceable anyway. So anyway, that's my my comment on political signs and secondarily director signage, or director and referendum signage. Let me move on the resolution M06, the committee has before it a red line markup of M06. At the June 23rd, June 23rd, 2023 meeting of the Board of Directors, that's June 2023 board meeting. There was a discussion that indicated some dissatisfaction about consideration of the fact that we were going to a contractor count of mail-in ballots in the election that was immediately about to be, process was immediately about to begin. But there was late consideration of M06 provisions at a very late date prior to the beginning of a new process in the counting of ballots. And that discussion, in fact, it was between the then and current liaison to the committee, as well as the then president of the committee, the board, who is no longer a member of the board of directors, new board of directors now. That discussion basically ended in an agreement that well prior to the start of this coming election process, and then immediately after the conclusion of the 2023 process, there needs to be or should be a comprehensive review of the M06 in regard to the contractor counting of votes. The only thing that has been done to M06 is to insert a brief mention in attachment A that the committee can delegate to a contractor the counting of mail-in ballots. That's all. Attachment A is and has always been oriented to and intended for the elections committee count of mail-in ballots. It has not ever been intended to include provisions that are expected of, processes that are expected of a vendor or contractor who is going to do the process. There's no evidence of any kind of a comprehensive review of the M06 provisions regarding contractor performing the balloting. It's just not there. And that needs to be recognized. The other comment I have on that, not on that particular aspect, but on the M06 proposals before the committee, there is a one-line amendment to attachment D, which is the online or electronic voting provisions attachment of M06. And in that provision, it's easily identified. It's a red line. It calls for the invalidation of a recorded online or electronic vote when a mail-in vote or mail-in ballot has been received. There is no indication in the material that I believe the committee has received indicates what's the basis, why such a provision like this. And I don't consider that to be at all a well thought out provision. What is required is that the process of balloting and voting, of counting and recording votes has to accommodate or has to prevent any other vote from the same lot being recorded when there is already one recorded. In this case, we would be invalidating a recorded vote that came in online simply because a mail-in ballot was also received. What should be done is a process in place, whether the balloting is solely one method or the other, another method, mail-in or online, being the sole process, or both are available, as was the case in 2022. There should be controls such that only one of those ever gets recorded. If that occurs, you have a mail ballot received and you've already got a recorded online or electronic ballot. You have to have a process that stops two ballots being counted. I just can't emphasize that anymore. There's the process that's got to be in place, and the invalidation of a recorded ballot is on the basis of having received another ballot. It just is not a part of election integrity. Anyway, I appreciate you hearing my comments. That's the end of my comments. Thank you.
Thank you, Jim. Does anybody, either other guests have a public comment at this time?
I'll address Jim's when I talk about what I'm going to talk
All
about.
right, perfect. Okay, so moving on, chairperson's report. I have decided I am not going to attach it to our agenda. That ends up getting posted to the website. It will be a separate document. Somebody wants to see what I do, they can ask. So for January, attended the in-person directors meeting on December 16th. Emailed Michelle to add today's agenda and our annual report to the website. Attended the Ocean Pines Work Group for the Spring Kickoff Expo committee meeting that was held on December 18th. Emailed reminders to the following committee: Budget and Finance, Strategic Planning, Recreation and Parks, about their resolutions. Responded to a question from the Recreation and Parks chairperson concerning charging document process, which we'll get to in new business because I want some further input on that. And then there's my task still to be completed, which I have all of the directors' meetings listed. I am reevaluating whether or not I will continue to keep attending directors' meetings since it's not required of me as a chairperson, because I've not received any guidelines, specifically. I can always watch the replay when I have availability. So, does anybody have any questions for me?
No.
About that? And then next up is we always give our board liaison an opportunity to give an update or report. Steve, do you have anything at this time?
Not too much. The board yesterday went through their budget review process for 3 or 4 hours, I think. And then my understanding from the president is the board will meet again to reach some final decisions, and then a packet will be prepared for the February board meeting to vote up or down. I guess I'm going by what I've been told is the history of both the Budget and Finance Committee review process, which was last week, and the board review process, which was this week. Both were considerably shorter than they have been in the past, which is frankly a testament to the work done by the staff in putting together documents and other information, and also the fact that, at least for now, our financial situation is better than it had been. So I would just to follow up a little bit on Jim's comments. Let me start off by saying my mistake. I did not see M06 on the new business. I've not even looked at whatever was sent, I guess, to the committee. Yeah, I understand that. I just didn't see it. I just didn't pay
I
attention.
believe I sent it overnight.
I assume that came from the elections committee, though.
Yes, correct.
But I will, at the June board meeting, there was a discussion about not only the process that we were going to follow for this past election, but the need to address the issues in the upcoming elections. I would just carry it a step further and just say the understanding that I had, that I think both the president and the vice president of the board, who is now the president, who is at the time was also liaison to the elections committee, was that the elections committee would undertake a complete review of M06 and all the attachments thereto, and do it in a timely fashion so we were not bumping up against the upcoming election season, which is apparently what we're going to end up doing anyway. I appreciate Jim's comments. I will review whatever was received. And if the committee has further suggestions, we'll see what can be done. But that's sort of where we are.
Great. Thank you very much. Moving on to unfinished business status updates. We continue to have one available opening on our Bylaws Committee that began back in November 2023. There may be potential more openings as we progress through 2024 because terms are ending for a couple of our current members. So the next updates are for Keith to document on our governance tracker. So C12 marine activities, I received an update from them on 12/20 that no changes were required at this time. He said they did not meet in November, so we can move, the updated.
I updated that one.
For that.
Yep.
C3 budget and finance will add it to their agenda at their next meeting, which is to be determined. So they will tackle that at their next meeting and give us an update after that. C07 strategic planning, their next meeting is January 25th, my upcoming birthday. We'll give updates after that meeting. And then, so they at least acknowledged this time that, they received the email. And then C13 is recreation and parks. I received an update from them this week on the 9th. And the committee recommends no changes to the resolution at this time and consider it reviewed.
So on C7,
strategic planning, yeah.
Should I change the date back? Because we went by our 30-day rule of no notice and just changed it.
Just leave it as it is right now. And then if they come back with some updates or whatever, we can update it then, because they may look at it and say it's fine too. And, okay. Does anybody have any questions on that?
No.
Moving on to the new business. I think the one thing I didn't have up to share is, and I don't know if somebody else looked at it, the update from Pam, which she does not
Save that till the end, maybe.
able
Yeah,
to
let's-
join us, correct?
Let's save that to the end in case she logs in. That way she can.
Yeah, I will say, I haven't even, I was gonna look down and take a quick peek.
So I would like to say that since we have
Oh, sure.
a guest here specifically for the art guidelines, that we start with that one.
Okay, so let me just give these to you so that I can tell Pam that I did this part. Can you give that to Audrey, please? And this is for committee members, so we and then actually, we should pass one down to Steve. Liaison, we included some, it's not the article that you just handed me. Y'all can do what you want. Okay, so we're going to table that update until she is able to join us. Moving on to I'm gonna, before we get to ARC, because that is our primary focus today, I would, because I don't think it's gonna take long, but the clarification of charging documents. Parks and, did I say it was? Yeah, the Parks and Recs, wanted me to find out, what is the process? He had a couple questions. What is what process does the board use for reviewing and making a decision regarding the charging documents requested action? And then I had included my answer, that it can be, charging documents are used two-way, either from a committee to the directors or from the directors to a committee. And that so I kind of explained that, that you create or if you receive the charging document from the directors, then we evaluate it, we go back to them. I think his next biggest question was, how is the decision documented and communicated back to the committee? So let's say a committee, we've done this before, we recommended that council look at something. We don't officially technically ever, most often in the past, gotten a specific response saying legal has looked at this. The only way we get an update is if our board liaison shares that information with us. There's no official piece of paper that comes back that says, yes, it has gone to legal, that action has been completed, anything like that. So,
Or we're not sending it to legal.
right. So is that fair to say that my answer back to him is correct? That there is no specific process in getting a response back, that it's kind of up to the liaison and all of that to get that answer to us. And then his last question was, what record is kept and where of that request, that charging document, and the decision once it's been completed, I guess. I said, I do not know the specific location where everybody keeps their charging documents. In fact, I keep a record of all of the charging documents that Jim received, that we have done in my time here on my own computer, you know what I mean? So I can reference those, but is there a spot within, the staff area or something that somebody could say, hey, was there a charging document and what was the result of it? If we were looking for history, I don't think there is, right? I mean,
So can we open the floor?
yes. Oh, yeah. So Robert's rules has been suspended so that our guests, then all comments can be made.
Jim, in C1, does it talk about charging documents?
Yes, it does, I believe. I think it's an addition that comes from the Colette Horn time.
Yeah, that sounds familiar. I don't think all of the things that you said are addressed in there. Like, I think you're correct. I don't think there's any specific feedback guidance.
Right.
I think it's kind of informal.
Yeah.
And I think you're right. Typically, the way we find out about it is either it was discussed at a meeting or the liaison had a discussion with somebody about it.
Yeah, see, I have C01 up, and there is no specific thing even talking about charging documents.
I've seen it. It's in writing somewhere.
So maybe it's just not.
Because the form is
The
posted.
form is there.
See if it's there's an attachment form, I believe.
It's an attachment,
So here's.
but there's no procedure that I can
Right.
Yeah,
remember.
there's the charging. Oh, it just doesn't discuss it in the body of the document.
Yeah, in other words, we got a document, but there's no documented procedures, who does what, when, how, and what the follow-up is.
So we actually submitted a charging document for
I think we
C01.
Yeah.
Oh, yeah, back in 23.
Yeah.
That never came to fruition.
Right.
So we had questions about C01,
Mm-hmm.
some different things that we felt needed to be addressed, updated, whatever, and nothing's ever happened with that.
Right.
No, I think as to that, we were holding the committee's comments regarding C01 pending what we thought was going to come from the executive committee.
That's
dealing
right.
with
Right.
That's right.
And the executive committee,
members being attached,
Yeah.
nominated to committees.
That's right.
That never, there was a
never-
discussion in the executive committee, nothing ever came from them, time expired, we were all done.
Okay.
I will say there's some new email floating around on the same subject, which I will share with you, but
Okay.
we're not. There's
Well-
nothing to do yet.
or what's my other option, who he did ask if I couldn't help him with those questions, who would I refer to him to answer about charging documents?
Who is asking these questions?
Parks and Rec chairperson.
Oh. Okay, well, my suggestion would be.
Bill something, I can't,
I mean, he's got a committee, he's got a board liaison,
yeah.
and my
Refer
feeling
it back
is.
to his lead.
Board liaison, because the issue is not really what this committee keeps in its records. The question is, what does Ocean Pines keep? As we all know, questions going to staff go through the general manager and come from, ideally from the board, or in some cases from a board member. My suggestion would be, and I'd be happy to meet with his liaison to, and even
Well,
him if he
I'll
wants to.
reply back to him and CC you and
Yeah, that's
his
fine.
board
Yeah,
liaison in the
I mean,
conversation.
the committee, this committee has its own procedures.
Right,
Park and Recs or Marine Activities or ARC or whoever,
mhm,
they have different procedures and each committee operates as they see fit. Whether or not this committee wants to recommend a procedure relating to
Okay.
charging documents or even when it's necessary, that's a whole nother question, but
wonderful.
that would be my suggestion as to how to proceed.
Okay, thank you very much.
And so we could probably knock out two birds here with one stone, because we have C01 on here.
Right,
So if you think that there's some discussion that's potentially percolating,
Yeah,
right? So I say we just let C01 ride for now
Yeah.
and wait to see what happens.
May move to
yeah,
February, so
and
we'll
we
go
do
ahead
have,
and just move that.
this
to
committee
February.
has
Yeah.
what I would call sort of some technical and conforming, minor, whatever term you want to use, suggestions to C01 as well. If we're going to do something with C01, we can wrap it all up in a ball,
Right.
but I'm not sure what's going to transpire yet, but I will
Okay,
send you what I've got.
okay,
And,
all right,
but I'm not sure that we've been notified to do anything yet.
right.
So,
All right, okay, so moving on, we are going to tackle the archive lines review of the red line document. John, Mr. Dilworth is the ARC chairperson, and our guest today to hopefully answer any questions we might.
I'm prepared to do that. But to start with, if you don't mind, I'd like to address Jim's comments on his sign concerns.
Sure.
The way we approached this was we wanted to better clarify what a political candidate was and what a political sign was. And a lot of what we've done with these guidelines is an intent to basically clean up the place, because there are way too many signs, there's way too many things going on in these lots that basically we think make the clutter the streets. Political signs are not like that. I mean, but the fact that there's that we shouldn't have a restriction on the size, I don't think we should be allowing somebody to put up a 4x8 sheet of plywood with a candidate's name on it. That's just going to be too overwhelming for the lot. But this is the one spot in all of these guidelines that I hope is the only one that will really need review by outside counsel to make sure that we are not doing anything right. We aren't saying we're doing this wrong or we're doing this right. We are saying this is what we would like to see. Somebody else with the proper authority and the proper background has to tell us whether this can go in or not. And quite frankly, when we did these in 2020, I'll guarantee there was no outside legal counsel review of the guidelines that went through that. It was all done by the board, and we didn't even get comments from all the board members. So we left in what was in, kind of expecting that we would get some pushback somewhere where things that we had done and things we would like to see didn't quite meet up with what expectations were and frankly what's legal. So, and that's where we are right now. So the way we thought to clean up signs was, oh, the other thing I'll say too is we expect the new council to review this at some point. And
So
what
they haven't done it yet.
they haven't done it yet. We expect it to be done. And what Elaine Brady is going to do, we're going to do the first reading of this at the next board meeting. And what we've already cut out all the sign provisions that we've modified, and we prepared a separate exhibit for council to take a look at, so that he can concentrate on that. And I'm hoping that that's all that's going to need it, because this is the 56-page document, and I think most of it is within control of the board to say yes or no. Quite frankly, now, I might be told differently, but this is the area that really needs somebody to say, are we stepping on toes, and should we not be doing this, or should we rewrite it? The time interval being left at 30 days, if you look at what our political candidate definition is, it's basically anybody that is running for office in the state of Maryland and has been properly certified by the state election board to run in the state. If you're not going to be able to put a sign up. There's no reason for it. But we didn't intend to say that when we did this, we kind of said, it's probably going to end up backing up to whenever somebody is officially a candidate, they can start putting signs up. And I looked at the law on that. I mean, that could be a year and a half before an election, where somebody could be a candidate. That may be the cutoff. I don't know. But what we did was just put the minimum required in here, just to put it out.
John, I think I'm right, but I haven't looked at this in a long time. I think I'm right that probably our Secretary of State has to, on a given date, I don't know what the date is, certify that these are the candidates that will appear on the ballot for whether it's a primary or a general election. And I would think that certification issuance would be the date that you would want.
Right.
Okay. That can I flag?
I thought the date was 30 days before the election.
The certification.
No, in the proposal.
The date we can put signs out is 30 days before the election, because that's the minimum period under Maryland HOA law, the way I read it.
Right.
But I don't believe it's fair,
Well,
quite honestly. Go ahead.
yeah. Well, I would suggest, however, that when you talk to council, you may want to flag one issue, which is signs, and this is not a big deal, but signs relating to write-in candidates. In other words, where there's a concerted effort to write in a person for a particular race, they might well have signs. They would not be certified to be on the ballot, but that you may want to flag that for council as to how to address that.
Right. Okay. But the other, go ahead.
Well, no. And part, I think Keith raised this as well, and as a general rule, I'll defer to Augie, because I only took one course at con law. But political speech is the highest speech for which restrictions are looked at, and in order to clear those hurdles, it's a very high hurdle, difficult hurdle to clear. There are permissible time, place, and manner restrictions on, for instance, political signs. As long as they're uniformly applied, those would be acceptable. And I assume that's what council referred to. But the other issue which you just raised, which is what's in the Homeowners Act. There is a potential for a conflict between what's in the Homeowners Act and what is either in the US Constitution, Maryland Constitution, or some other statute relating to elections in the state of Maryland. That we're not going to be able to resolve that.
Right.
That's a conflict that only a court can resolve. It'll go to the Court of Appeals or whatever. I would assume that council will look at this and say, for for Ocean Pines, we are governed by the Homeowners Act.
Right.
And that's what, any restrictions, as long as they're equally applied, would be appropriate there. That would be my thought, my suggestion.
That's where we limit our review to.
Yeah.
Rather than opening up a whole big box.
So when you guys did the review, did you have a copy of the applicable section of the Homeowners Act?
I looked it up.
Because paragraph B specifically says may not restrict or prohibit.
Yeah.
How are you getting around that?
Well, hold on.
I thought there were timelines in there.
There's,
So no, the timeline is the only exception.
Okay,
It says you can put timelines in there, but everything else on private property may not restrict or prohibit.
no,
we're not prohibited.
that's not entirely correct, because in C, there's the restriction language, which says a recorded covenant or restriction, a provision in a declaration, or a provision in the bylaws, rules of a homeowner association may restrict the display of a candidate sign or a sign that advertises the support or defeat of any proposition. So we do have the authority to place some restrictions. And as I say, I think the restrictions are going to be limited to time, place, and manner sort of restrictions. In other words, the time limits, the manner, in turn, probably, which would, I think, would include size, where on the property, where other property can't be put on common areas, for argument's sake.
Right.
Those, I think, would all be acceptable restrictions. As long as they're uniformly applied to everybody, I think we will be fine. I don't see B as limiting the authority to regulate signs in a time, place, and manner.
No, I understand what you're saying, but even in the paragraph that you're citing, covenant, restriction,
Right,
declaration, or bylaws.
right, all
So
of which we have.
Yeah, but we have nothing in our bylaws restricting it. The DRs do not restrict it. So right now, the only thing that's in writing that restricts it is this guideline.
Well, true, except that both the DRs and I think the bylaws give the authority to ARC to undertake this function. I don't.
So I think we need to move on to the discussion part of this because it's bigger than this issue. This is one of the issues.
Well, let me put it, if you're going to have council review the signage question, then that question that you're raising should also be flagged by council.
Right, we are purposely making sure that at least this is reviewed by outside.
That makes sense.
So, because I'm there.
Yeah.
And like Jim said, this provision has been dragged through guidelines for decades.
Yeah.
So we've just reiterated.
Didn't we share that? My memory's a little rough here, but didn't we share this?
Yeah,
a
good
while
point.
ago, right? Yeah.
Going.
So we had
Mhm.
sent
We've done this
yeah.
multiple times. This is not the
Yeah.
first time. Back in 2020, we did it, but I don't think it ever actually made it to the committee.
Yeah.
So it's been done multiple times, but
Okay,
So
I would like to start on this topic if
go ahead.
if I may.
Yep.
So I would like to start out by saying I've never read a DR until the last couple of days. I've heard about them. Jim's talked about them. I've never read one. So I pulled up mine
Mhm.
and I read it. And I just want to run through this real quick just to make sure that I have this understanding correct. The DR as a governing document, it seems to me actually gives the authority for the art committee, because it's at least in mine,
Yep,
It's-
environmental control.
Yep.
all.
it's a different name, but
Yep.
it's the same thing. So the authority for the art committee appears to me to come from the DR. And the way I interpret what the DR says is it's the responsibility of this committee to essentially explain this DR to whomever it needs to be explained to, amplify upon it, clarify, and provide whatever guidance is necessary so that it can be executed properly. And that's essentially the charter of the EC or the ARC,
You're right.
right? And as far as our bylaws go, the only thing I see in the bylaws is that the bylaws just establishes the committee and puts people on it. But other than that, it's ARC's responsibility to take the DR and say, here's what that means. Because some of the language in the DR is kind of general.
It's,
It may talk about maintenance or, whatever. Somebody may say, well, what does that mean? So the idea, the way I understand it, is that this document helps clarify what's in the DR.
Exactly.
Okay. So if I've got that correct, then I've got some general, before I get into specifics, I've got some general concerns. So number one, there's restrictions or prohibitions in the DRs that we don't comply with. I'll give you an example. First right of refusal. Anybody know what that is?
Yeah, that, I read that. I
Isn't that
think we're
crazy?
well beyond that.
No, I'm with you. I'm with you. But my concern is that because we in these sections don't periodically get together and vote and remove stuff like that, that it's still in there,
It's still in there.
right?
Yep.
And so I wonder, and we don't have to discuss this right now, but I wonder if stuff like that should be addressed in here, under some kind of general comment that says, maybe some statute came out or something that overrode this and therefore it's no longer appropriate or enforceable but either that, or we all in our sections, we all got to go back and got to put our heads together and vote and get this stuff taken out. Because there's stuff in there, which doesn't really make any sense. I don't think would be legally enforceable.
That's what he said.
That we don't do, and it's not in there. So that's my first concern. My second concern is that there's stuff in here that's not in the ARC guidelines. Or no, I'm sorry. There's stuff in here that we in Ocean Pines don't enforce. And the example I have is rentals. So there's language in the ARC guidelines and about Airbnbs and boarding houses and things of that nature, but yet we all know that Ocean Pines is full of rentals. I mean, they're everywhere. There's a house right down the street from me that is openly, publicly advertised as a rental. I don't think anybody lives there. It's just a rental. So I have a concern about that. It's stuff that goes on every day in Ocean Pines that's been accepted for whatever reason, but in writing, it's not approved. So I have a concern about that. Because things just start getting muddy and messy, right? And then, just one more cool thing that's in the DRs. According to the DRs, if a non-person buys property, and I don't know if you remember, we went through this discussion. So, there's a big thing right now where finance companies are buying up single family homes, right? They're talking about passing a law in Congress, right, to outlaw it. But it's happening. These big banks or big finance companies are buying up single family homes and then turning around and renting them out or, jacking up the prices or whatever, right? Well, in the DRs, there's actually a provision that says if a non-person, like a company or finance company, buys the property, that they're not members of the association. They don't get voting rights. I thought that was interesting.
Didn't we address that in the
We talked about that.
bylaws too?
Well, what we said was if they can't be a member of the board,
Yeah, it's a kind
they can't be a member of the board. But theoretically, we might be giving votes to businesses that, according to our DRs, and we don't have to discuss that right now. It's just an
Well,
example.
that would be called out at the time elections and
Yeah,
and ballots are set
They
out.
would have to call that as an ineligible
Right.
recipient of a ballot.
So a business itself cannot vote. A trustee can vote. I think that's where the rub was.
Yeah. And then my last concern here is that the DRs cannot be fundamentally changed. The only way that the DRs can be fundamentally changed is through a vote of the people in that section.
That's
Correct.
Okay, so when we have a committee who's tasked with interpreting what's in the DRs, clarifying, amplifying, basically making the DR usable, because I got to keep in mind here, and I don't think this document's really usable for your average everyday.
What section are you in? You're in one of the original sections?
Yeah.
Yeah, so all the DRs for those early sections, they're mirror images of each other.
Right, yeah.
I'll say
I
that.
noticed that at first. I thought I was doing something wrong.
No, they're all. the same.
Yeah. But so your tasking is to take what's in the DR, make sense of it, and in this case, publish it in something that's usable in a form for people to be able to reference and do it right. But it would seem to me that just, human nature over time, at some point, there's going to be a line where what is being put in here potentially is no longer tied back to the DR. Because I would have to imagine that, and I always think about the court of law, you know, we talk a lot about how do we stay out of court? How do we stay out of court, right? So if I were standing in front of a judge and I had to defend something in this document, it would seem to me that because this document is essentially an addendum to the DR, I'd have to somehow be able to tie it back to the DR and say, well, if you look at this paragraph in the DR, it talks about this, and we're expanding on that. But if I can't find a section of the DR to tie that back to, then in my mind, that's beyond the scope. And I think that no matter what, that will happen at some point. And I guess my question would be, and we don't have to answer it here, we're not going to answer it here, is who prevents that from happening? So those are just my concerns in general. And I would like to, I guess what I'm going to say is my personal opinion after reviewing this, I think the red lines in this document, some of the red lines in this document have crossed that line. That's just my 2 cents. It's not the committee. And I would like to just talk through some of those things.
Well, first of all, I don't think the guidelines are looked at as something. Well, there's a hierarchy of laws here. You've got Worcester County zoning laws, you've got the deed restrictions, and you have guidelines. To me, when you come down that line, the only thing that's happening is they're becoming more restrictive. Each of those documents is becoming more restrictive. The DRs restrict the zoning. The guidelines provide detail and restrictions that we feel, based on our interpretation of what the intent of those documents are, we're complying.
Right.
So that's really what it comes down to, is we are charged with doing the best we can to make sure that we are not doing anything that damage this community, damage the people's home values, maintain the neat, orderly appearance. And quite frankly, that's subjective, you know?
It's a gray area. You're going to eventually, whether you want to or not, you're going to end up in a gray area.
Right, but we've never looked. I mean, I've been on the committee for 6 years, and this is the second time around. But when we've looked at things, we've never said, "Oh man, this has to tie back to the DRs." All we're doing is we are creating more usable rules that will hopefully augment what the DRs don't say.
So that's actually my point, right? That if it cannot be tied back to the DRs, whether it's a good idea or not, where does the authority come from to essentially create out of whole cloth that idea and put it in here? Because the existence of this document comes from the DR.
The
existence of the committee.
The reason for that document comes from the DR.
Right.
Well, and let me add one other thing that I think is important, because particularly with changes in M01, there is a distinction between the role of CPI and the role of ARC. And ARC's responsibility is to address, for lack of a better term, the issue of variance. In other words, if there's a violation, there's a claim of a violation, or if a violation exists, that the onus on proceeding with that lies with CPI. ARC is basically charged, and correct me if I'm wrong, but basically charged with, here's the guidelines. Homeowner Smith comes in and says, well, I need to expand my driveway 6 feet on both sides. I'm within my property line. I've talked to my neighbors. It's okay. Can I do that? And that at that point, yes, okay, you can. No, you can't. Or you get 4 feet, but not 6 feet, whatever the ultimate decision is. And that's the difference. I've always felt that these DRs, and I say this a little tongue in cheek, are drafted by very lonely attorneys who sit in windowless rooms with no ventilation and fluorescent lights beating down on them, for this development, that development, and they're done by the company that's building it anyway. And when they phase out, they don't really give a damn what it says. Now, that may not mean much in a court of law. I get that. But I don't know that you need a direct tie between our guidelines and a particular provision in a DR. Because, by the way, there's also a hierarchy in homeowner law. In other words, there's the state law, there's the charter, there's the DRs, the bylaws and the resolutions fall below that. But I do think that the notion that ARC is charged with maintaining the general ambiance, atmosphere, architectural purity, whatever term you want to use, of the development it's basic to function is.
That is our function.
Yeah,
And
that's what the DRs say.
right, and that's your link. That's
what the
really
DRs
all
say.
you need to tie those guidelines to their function.
No, I get that, but there has got to be a limitation on it. There's got to be. You can't have one committee instituting rules for 8,500 some odd homes in a vacuum.
I don't think they operate
The
in that.
board will vote
Well,
on that.
but just as it says in the document, nobody no other department or employee of Ocean Pines has any authority to make any decisions relating to these guidelines or section declarations.
That's correct.
So they're in a vacuum.
No, because both the board can take action and frankly, the membership of the area governed by that DR, as you point out, can take action.
Right.
So the restriction that you're citing applies only to a particular department within Ocean Pines or an employee of Ocean Pines. Doesn't say that the committee operates in a vacuum. There's an issue. It could be raised to the board. It could be raised to that section that governs the DR that governs that thing. But the language that you're citing only applies to the operational side of Ocean Pines, that which falls under the general manager.
Do you think that the board has authority to approve or disapprove what they put in this document?
Oh, yeah.
Yeah.
Where-
They can knock us off the committee if they
But
want.
where does it say that?
I think it's
It's not in the bylaws. All the bylaws say that they can do is establish the committee and appoint the members.
okay.
Yeah, but the board has plenary authority to act on behalf of Ocean Pines. That's why there is a board. We don't need a specific grant of authority to make a decision for an advisory committee,
The reason I ask that
because
is,
they're only advisory.
no, I get that, but the reason I ask is it just seems to me that it's a circular issue where the DRs say that the only people who can change me are the people that live in this area, in this section. It's the only people who can change me. And then we have an advisory document which attempts to clarify and amplify what's in that document that now can be changed by the board made up of members who don't live in that section. So let's just say that all that's correct. And the board can say, yep, good to go, and they sign off on this. What would stop the members of, say, my section from getting together, holding a vote, and invalidating all that?
The short answer would be I don't know. But if the question that you're asking is, I think you could make an argument that Ocean Pines can be better served to operate under one set of DRs.
No doubt.
Oh,
We've
yeah.
said that for years.
That's not going to happen, but we would be better. That aside, if the issue comes down to a conflict between a section of Ocean Pines and the authority of the board to act on behalf of Ocean Pines as a whole, at that point, to be quite honest with you, I don't think you have any choice but to see what a judge is going to say.
Yeah.
But I don't think you need to resolve that. you know, in theory, both bodies would be free to take action. If a conflict arises, that's why you have a court of law, to settle conflicts.
No, and I'm with you on that. I want to make sure that we don't unnecessarily put ourselves into a position to have to do that if it's not absolutely necessary. Jim, were you going to say something earlier? Did you start to chime in?
Sorry, I didn't understand what you just said, Keith. What did you say?
I was asking you if you were going to chime in earlier, if you were trying to say something and we cut you off.
No.
So let me walk through my stuff, and this may be justified, may not be justified. These are just my thoughts after doing this review. So the very first thing is this title right here, guidelines.
Okay.
This title makes sense to me. However, all throughout this document, it uses the word regulation. This is a regulation, that's a regulation. So it seems to me that if what's in this document is regulations, then this is not accurate. Is it a guideline or is it regulation? So that's my first concern. Yeah, for example, here on page 3, to ensure the plans for landscaping of open spaces conform to the regulations prescribed herein.
Okay.
Our committee shall have the authority to set up regulations as to the height and size. The term regulations used throughout here. Sign and flag regulations. Yeah. So that's the first thing is guidelines versus regulations.
Isn't it both guidelines and regulations?
Well, that goes back to my question of if the DRs can only be changed by the people in that section, guidelines, it seems to me, guidelines, they're tasked to do, literally, but creating new regulations that are not otherwise in the DRs, that's where I have to question.
Well, I mean, regulations is kind of a flexible term somewhat, I think. So I just don't think regulations implies that it's in the DRs. It's sort of a level in between, maybe a guideline and a declaration of restrictions.
Well, that could be, but then it goes to the question, by what authority does that advisory committee have to make regulations for Ocean Pines?
I mean, they're
If you look-
guidelines and
Yeah, I mean,
regulations.
The only thing we have the authority to do is create this. The board is the only one that has the authority then to say, these are going to be used.
Right.
So
Right.
we're out of that. I mean, actually, we are now completely out of the violation process. We don't touch violations anymore.
Right.
And the genesis of that comment about these are the only people you can talk to, that is a response to a serious problem we have, which is people are listening to neighbors, they're listening to social media, they're being told how to get around permit processes. And we actually had an employee tell somebody that they could do a certain thing with their lot, and they did it. And it came to us, and we would never have approved that. So that is what put it out there to say, if you want the truth, if you want to know what you can do, you've got to call CPI, because they're going to look at these and they're going to say, section 200.2A says you can do this. And that's all they can do. If they want to do something else, then they come to us to try to get relief.
Right.
And that's the process that's in place right now.
Right.
The term regulation to me implies there's more specific, I think, numbers, measurements, things that they're talking about. And guidelines is sort of a more like broad standard. So I don't know if I have a huge problem with you interchanging those words.
Right, and I think that's accurate. And then not only that, by keeping this document broadly speaking as one dealing with guidelines, then the committee has the authority to grant the variances from the regulations that are in place.
Right.
I mean, people have issues.
That's fine.
I mean, the board members got an email, I don't know how many months ago, about a woman dealing with an RV vehicle that, she has a child who has special needs and special care requirements and all that. And it's easier I don't even know if it ever came to you, but her story was, it's better for her and her child for the RV to be on her driveway so she can pack things up and, that sort of stuff. And she needed, I guess, what she was looking for was a variance of some type. But I mean, it just, my point is not whether that's legitimate or not. My point is that's an issue that the committee could then look at.
Mhm.
So we can grant the variance from the regulation.
Right,
That's,
right. I mean, my limited view of us as an advisory committee begins and ends with this. Once we have this, we are the only committee out there that does not have to go back to the board to get permission to do what
Right.
we're doing.
Because they signed off on that.
Exactly.
Yeah.
Yep, because we are now on our own, and the hope is that we're not a bunch of cowboys out there doing whatever we think we should do. So what we've really tried to put together here, and what I've tried to put together, is a group of people who are of the same mind, but not necessarily like-minded, of what our mission is and what it's going to take to actually do it.
Right.
And that is the source of these guidelines. They are situations where things had to be tightened up, things had to be better explained. We wanted the confusion out of this. A lot of these things were, the wording just went on forever. I mean, heretofore, party of the
Right.
third part, all that stuff is gone.
Yeah.
It's more direct. Everybody should be able to pick these up and understand exactly what's going to be required.
We call that the user friendly.
Exactly.
It's discussed
Yeah,
here a lot that
I'm with
if the
you.
residents are looking at this, they
Residents are
really
looking
need to be
at
able to understand it and not get bogged down in all of the fancy stuff around it. They just want to look it up and say, can we
What
have
can
this?
we
Can we
do?
do this?
Yeah, and the other thing that struck us is over the period of time that at least I've been on this committee, the characteristic of the residency of Ocean Pines has changed. We are now more of a full-time retirement community than we were a vacation home that in the beginning you could actually camp somewhere if you owned a lot. We are so far away from that now. And the problem with the DRs, like Steve said, is they were so open that anything could be interpreted.
all they want to do is sell a lot.
Yeah.
The original authors just wanted to sell a lot.
They wanted to sell lots.
They
They
don't
put
care.
no limitations on anything. If you were to pick up the DRs of any community that's probably been done since the mid-80s, they tell you precisely what you can and can't do. And I know for a fact, there's a couple developers out there, I'm not even sure they allow any variances. You want a fence? This is where your fence goes. This is what your fence
Yeah.
looks like. You want a different color? You want it somewhere else? You don't get a fence. And that would be so much easier.
It's too big a community.
Yeah, so we make a lot of friends, but we also make a lot.
The next thing we already talked about, which was the political, I don't think we need to talk about that anymore. That's more than likely going to council anyway. They're going to make a determination about that.
Right.
The next one is this, and I think I mentioned this earlier, about the rental properties.
Yeah.
There's specific language in here that you basically can't have rental properties. And then you also added this, includes a kennel-like business for animals or temporarily boarded for a fee. That one, I want to say there's actually something in the DRs about kennel or not having kennels like in your backyard or like a kennel or something. So to that extent, but I know that there are people who pet sit. And
That
who,
setting's different.
and who you could like board your dog with them over the weekend, but it's inside their house. So all I'm suggesting there is if that were to stay, maybe that needs a little bit of clarification, just in that regard.
Yeah, we put that in.
Because it says kennel like.
We put that in because we got word that there was a resident here who was taking on more than one dog at a time to board. And the county says that if you have 5 or more dogs, you need a kennel license. Well, 5 or more dogs is a hell of a lot of dogs. So, we were hoping to knock that down, but
Yeah.
we figured we wouldn't do anything. But 5 or more dogs, you need a kennel license. So if they're sitting there boarding, that meant we just don't want that to get out of control.
No, I get
Maybe
it.
there's something where you say less than 4,
Yeah,
less than
that's-
5 or
right,
something.
yeah.
You keep
Or-
it out of the kennel.
or that you can, no outdoor facilities, if somebody's dog sitting, it must be inside their home. I don't know. It just,
Yeah, that was an add-in based on, and a lot of this stuff was precisely that. Things that we have run into committee
yeah,
where It just wasn't properly explained. When we were trying to make our point to the homeowner.
So this next one is that, in two places in here, you essentially say that you can enter the property and take property without warning. And to me,
Where's that?
well, so
there's
one of them
section, I've
is,
got it right up right there.
600.4.
Under the
yeah,
signs
right
and
there.
stuff. Yeah,
Yeah.
you look at A, you've got it in red without.
Without warning. And that, to me, that violates what we just went through with M04.
Is
Yeah, I
that a
don't-
trespassing question or like legal?
And that's in here twice. It's in there and
So this is 700.1A.
600.
600.4.
It's on the side.
This is, wow. Yeah, what we're saying is if you put signs up,
I think council will flag that.
Or a flag.
no, there is definitely a restriction there because if it is in the right of way, road right of way, so in other words, we
Right.
own a certain point, it can be taken. Now,
Right, but
what the thing is.
But that's not what it says.
Yeah, that's not what it says.
Well, but that's what CPI does. CPI will call those people and they'll give them a warning. They'll call the people that are putting up the contractor signs and the median strips. So those kinds of things, the median strips.
But
they'll yank them.
We actually had somebody here today that had somebody enter their property and take a sign.
Oh, really?
But
Well,
this
still-
pertains to signs on lots too.
It's two different provisions. This one is 600.4A. The other one dealing with right of ways and easements is 600.2.C. And I don't think there really is any restriction. If a sign or the flag interferes with a right of way or easement, they can yank it. I mean,
Right.
That.
Absolutely.
That's not a question.
Yeah, absolutely.
So the only one is this.
This one.
Okay.
And I would assume that's one of the ones that council will probably take a look at.
That's not one we asked them to, but you can certainly bring this up.
Well, here's where I think part of this has its genesis, and I'm a little late to some of this, but a year or two ago, there was quite a
Mhm.
conflict within the community dealing with signs that were being posted, dealing with the unfortunate demise of a 13-year-old boy.
Yeah.
And people were posting signs on their front lawn.
And they have flags,
And
they have little.
some had flags, some put them in their windows and all this other stuff. And at least one board member, immediately asked that the CPI come along and yank those signs. I think a couple of them got yanked. I don't think they ever all got yanked. I mean, they were still around. If you drive through Ocean Farms, you'll still see them. But that was, I know that was an issue just a year or two ago. And I assume that the authority to do so is what is in here. So you may want to flag it. These are not political signs in the
These are
sense
not political.
that we're talking about, ballot issues of candidates, but they are issues of perhaps social import.
But
Which
Correct.
I'm not sure you want to get into, but I
But
mean,
this-
Well, it's
600,
Walk a fine line.
600 addresses political signs.
Well-
So why wouldn't that include political signs?
Well, I don't know.
well, so that, I'm gonna talk about that in a minute, because this is all falling under 600.
Yeah,
And-
600.3.
And because one of the other, right, so one of the other issues is that you've added and flags to this,
Yep.
right? So, so now, I envision somebody going onto somebody's private property and ripping a flag down off of a pole and taking it.
Well, I don't
And
think,
so that's private
We have
property.
a
on
flagpole
private property.
that's 20 feet high. Is that not allowed?
if it's, I know that if it is on your property, definitely CPI will not go on there and take anything.
But that's not clear
That's-
what
Yes.
this says.
I know.
Yeah, and so, so that's one of my other issues is about flags. Because, in 602C,
It's on the land.
it says, it talks about location. And it was understood before that but you put in the new language, but the new language to me, this sort of muddies the water. Because it basically says that, you can't nail anything to a tree and the signs have to be in the front yard. But when you added in flag without specifying that you're specifically talking about it's flag, comma, advertisement or decoration of any type, that potentially could be interpreted as, an American flag on a pole. And a lot of people have their poles. I have a pole in my backyard. I don't have one in my front yard. I got one in my backyard. So I just think maybe that needs to be looked at just to
Well, the
clarify your
intention was to bring flags under the definition of a political sign that are specifically for a political purpose,
Oh,
not
political. Political.
Let me ask you a question. My neighbor across the street has a flag pole, US flag at the top, Baltimore Ravens right below it. There's another flag pole on Ocean Parkway going towards the north entrance, has a big Cleveland Browns flag.
Mhm.
There's another one, I think, for the Seattle.
We're an eclectic group out there.
Yeah, another football. Now, those are different than the numerous
Political.
Trump signs, 2020, 2016, 2020, 2024. I've actually seen a couple of BLM signs, Black Lives Matter signs. You're not trying to get to all of it.
No,
You're trying to get to the.
we are trying to get to the flags that have a candidate name or a slogan that is readily identifiable with a
Yeah,
candidate.
okay.
Now, maybe we haven't done that clearly enough, but we're not going to go around tearing down people's Cleveland Browns flag.
Right.
That's clarified enough in here then, because if somebody had a decorative winter flag, we have decorative flags out, whether it's a small little one or a small
Things that
state.
spin in the
Yeah.
wind.
Yeah,
I have those.
So I,
My wife puts them out there every season. Got some flying out, but it's
I'm not
like
putting
something
it
high
for
up
the
there.
seasons, but yeah.
Right, right.
But you know what I mean, so are we talking about
Yeah.
any flags, or are we really specifically?
yes, just from what Steve said, from a social standpoint, we're in an election year that's going to be highly contested.
And they all are.
And, well, I think more so this year. And whether this is a good idea or not, I'm not sure this is good timing during the election year
Just
to go around and start taking people's flags for their candidates. I could see this.
Yeah, that, I mean, we know,
Let them hang it inside the house then if they
but there's
can.
no intent for us to step on people's freedom of speech. So and that runs in that category, if you ask me.
Yeah.
But this again was what a political sign is, what it deals with, and when it can go up and when it has to come down. Not
Yeah, so
not when we're gonna run off property and yank them all.
I would just say that, to me, it was not clear in this particular paragraph.
That it's political.
Well, yeah, the differentiation between a political flag versus a football flag versus a national anthem. Maybe this
I get
language
it
here
now.
just needs
I
to
get
be tweaked a little bit.
Again, my suggestion would be that's something council could deal.
Yeah.
With what?
Ask
The
council.
distinction you're trying to make between, the Cleveland Browns
Right.
flag and the whatever, Biden flag or the Trump flag or whoever, I don't care who. That sort of thing.
All right.
Council would have to chew on that one.
Yeah.
Right, and the other thing, we don't honestly expect that this is gonna go down as written. So we're expecting some
Tweaking.
tweaking
Yeah.
to say, like this. I mean, we hope we get some, frankly, because we don't want to put anything out there that's actually gonna muddy the water. We're trying to clean the water up.
And anytime you're dealing with documents this big, it doesn't matter how hard you try. It may make perfect sense to you, when you're writing it. But then when somebody else comes in completely fresh and reads it,
And frankly,
yeah.
I can't tell you how many times I've looked at this thing, and I won't guarantee that there aren't sentences I'm
Mhm.
just
Oh, yeah.
Fill it in.
Yeah, there's some sentence structure and punctuation.
And I'm not-
But the problem is, after a while, you get blind to it.
Exactly.
You just get blind to it. I know that happens to me, and I just have to put it away, and come back to it like
Yeah.
a week later or something.
Yeah, well, I'm hoping the comments aren't about grammar. It's a little bit.
That's the last.
A question on signs, though. How do you control signs that are oversized that people put in their front windows? I mean, it should be addressed
It should
somewhere
be addressed. I mean, that would be,
because,
but that's something that they might get a violation for. That would be up to CPI. If that fits in the category of a violation, they would violate those people.
okay,
But they couldn't go on and
Knock on their
Take-
door.
Walk
take
into the
it down.
house.
down,
grab the sign.
down.
yeah, they need a
Yeah.
court order to get
With
it out.
MO1,
Well, I think
if they don't do it, I mean, the end of that line, if you're in court, we're gonna get a court order, which
Right.
they're gonna pay for.
Mhm.
So, and I don't even know, I'm not the one that's even gonna determine what goes to court and what doesn't. That's not my problem.
I just asked the question
Yeah.
because in another organization I belong to, one of the ways they get around it, they put the signs in the windows, so we had to change regulations.
Yeah, well, a sign is a sign as far as I'm concerned. As far as if you've got a display like that, it's on display, but it's out of our reach.
Okay.
obviously.
My, the last one that I have, and then I'll yield to anybody else, is this 101D1. It's under general provisions and purposes, and it's new language. And it says, any homeowner who plans to do their own home improvement work, comma, or new construction work, period. By the way, this is the one where the sentence is broken. Must provide evidence of either a license or their relevant experience
Yeah.
to be able to satisfactorily complete the work required.
Oh, geez, I just broke that this
Okay.
morning.
So I'm
Okay,
Fix a toilet.
so first of all, it is required that any work done in Ocean Pines is done by a licensed contractor.
Yeah.
Define any work,
If you need work, yep.
because in the paragraph before it, it includes landscaping. So you're saying a homeowner can't go out and work in the front yard?
No, a homeowner can do that, but what we've seen is we have violated several properties where some homeowner went up with a hammer and nails and sheets of plywood, and they've hammered plywood on the side of their house, and they want to call that an entranceway. So that doesn't fly. We're giving the benefit of that. Homeowners, as far as the county is concerned, are allowed to do their own work. So what we're saying is, depending on really, I mean, I know it doesn't say this, but it's gonna come down to what kind of work you're gonna do. Are you gonna dig a foundation? Are you gonna put electric? Are you gonna are you gonna put plumbing in? Things like that. There will be certain things that you will need to show that you have the capability to build that so that it goes up right.
Well, who you're showing that to, and what are you showing them to prove that?
What? Oh, you mean,
Art, right?
yeah. In the past, recently we had a situation where somebody's doing exactly this. They're blowing out their foundation. They're doing all this big thing, and there's no contractor's license on the application. So I turned it over to Josh Vickers, our senior inspector, and I said, Josh, go check this guy out. If you are satisfied that he can do it, fine. I'm not going to be the one that can say this guy can or can't do that. These guys deal with people all the time, and they're the ones that are going to have to approve it. So to me, that's a CPI function. They have the expertise to determine whether somebody has got the capability of doing the job.
But that's when the permit is, the application for the permit, or I'm sorry, the permit process.
That's in the permit process.
Right, and so on the permit, or the application for the permit, you have to identify, I think.
You have to identify
Who's going to do the work,
who's going to do your work and
Right.
what their MHIC or
and
homeowner.
CPI would then check, is the license in effect, or is there no license? If there's no license, then
Then we're going to ask,
go, okay, how good are you?
right?
Do you
And
know what the hell you're doing?
the county,
Yeah, but how do you answer that question if you've never done it before?
You're probably not
Probably
gonna
won't
get
meet the
approved.
standard.
you got to bring some
You probably
licensed
gotta
help.
get a contract.
Pouring a
If you-
foundation,
you
I've
stand-
never done it
you
before.
stand- Wait, no. Think about this for a second. If you're there and the inspector comes in and says, I'm looking at your application. And it says you're gonna do the work. What experience do you have in laying a foundation?
Yeah, but you're
I-
using this
but-
extreme,
but He says, well, I've never done it before.
but you're using this extreme example of a foundation. That's not what this says. What this says is any alterations to the lot, including driveways, patios, sidewalks, and landscaping.
Okay, well, landscaping, I think that you guys have, you're sort of, you know that. I mean, a homeowner can go out and do.
Well, the
landscaping.
homeowner can do landscaping. We're
Right.
talking about wholesale changing of
Structural changes or changes in the property.
the characteristic of a lot that would
Yeah.
probably alter natural flow of water. I mean, we're all worried about that. So
Well, I'm with you, but all landscaping alters the flow of water. You could change one plant for another, one plant that's super absorbent and one that isn't.
but that's
That
my-
argument could, but that argument could be made. Any kind of landscaping could affect the flow of water. I mean, this to me is an overreach.
Well, okay,
We need
the
something.
answer, when you all may want to go back and either define landscaping or strike it, I don't know. But I mean, if that's the, I mean, we know what driveways and foundations and structure of the house and all that sort of, we. know
Well,
what that means.
I'm just gonna right here on recorded video, throw myself under the bus. I have a beautiful paved landing in front of my house.
You have a great yard.
I did that.
Okay.
I've never done it before. I watched a YouTube video. I went out and bought a saw, went out and bought a rock saw. I watched a YouTube video. Now, it took me probably 3 times as long as what a professional would have done it, but I did the base work under it. I did a little retaining wall for it. I laid all the stone. I put all the pavers in. I sealed it. I maintain it every year. It's gorgeous. Nobody knows that some knucklehead homeowner did it, but I did it. But I could have never proved that to anybody because I'd never done it before.
But you also never applied for a permit either.
It was actually part of the remodel of my home to have that there. So it was approved aesthetically as, yes, this is appropriate for, the house, the color, the look, the placement.
Right.
But it was never discussed who was actually going to do it.
That's what happened then as opposed to what happens now. I mean,
Right. Yeah, I mean, we could put some better
I mean,
parameters
I
around.
hear what you're saying. I mean, the kind of things you're talking about, that's absolutely disastrous.
You
So
might,
I'm with you on that. I just,
you could change like relevant experience or knowledge, like something to like at least make it more flexible if someone is taking on something and you are comfortable that they're, Keith clearly did the work to do the job right.
Right.
And,
Well,
someone
Right,
might
and I've done
not.
stuff around my house. I laid pavers in front of
Right.
a new
Yeah.
porch that we had put on.
that's what I'm talking about,
Right.
neighbors. Yeah,
Yeah,
yeah.
We had to do that to get to our son to our ramp because the yard was all rocks. We
Right.
had to put a few pavers down, make our own little mini sidewalk because his wheelchair wouldn't go
And
across the rock.
handicap ramps are another thing that, I mean, you get one of those, and they have, and that's one of the things we changed in here too, was it used to cite another law somewhere along the line, but basically Maryland doesn't have a law for that, but there is a set of guidelines out there as to what you can do for handicap ramps, so that's one of the changes.
So I don't want to beat this to death. I'm just
I
suggesting
hear what you're saying.
that maybe this is some word tweakage here or something to make it more specific about what you're really concerned about. It's, somebody going out and changing out all the plants in front of the house, or I don't
Yeah,
know.
you
For
better hope none of your
landscaping.
Neighbors saw that are watching this.
It's too late. It's
For
recorded. It's-
For landscaping, it's tied to impact on stormwater runoff, but you
Right.
might say like appreciable impact rather than just impact, so it's
Right.
not like a de minimis impact, like changing plants from cactuses to shrubs.
Yeah, I mean, the thing we're worried about there, is people have done things to their lots which absolutely destroy the
Yeah.
natural flow of water.
Yeah,
I mean, we got a call from somebody on this, my neighbor's digging a 3-foot trench between two.
It's a big issue.
yards.
Especially with
That
the
was something
stormwater
else I thought was interesting in the DRs.
which is
That
massive.
the DRs actually require that the first level of living space of all the homes in Ocean Pines be 7 feet above sea level. I thought that was interesting because most of Ocean Pines is under a 4-foot FEMA flood zone. So you come up 4 feet, right? And that's considered to be the 100-year flood, right? And so you want to be above that 4 foot But if it's at 7 feet, or you're another 3 feet above that, there is no way. There's no way some of these homes in here are 7 feet above sea level.
Well, I think it's mean,
sure?
I think it's mean high water is where you have to be.
And then, because code requires.
That's the first floor living space, right? Not
The
the
first floor
foundation.
living space, yeah, because code requires today, and maybe this might not have been code when Ocean Pines was built, but today code is that all roads and streets cannot be below base flood. So for Ocean Pines, base flood is 4 feet. So for most of Ocean Pines, kind of makes sense if you go out and look, and you look to see where the road is, and fire hydrants. Fire hydrants have to be above base flood. And so you'll see most fire hydrants stick up a little bit from the adjacent road surface, right? That's because they got to be above base flood. But then you look at some of these properties and they're like a bathtub.
Really?
Yeah.
Oh, yeah.
Well, this is up higher.
Driveway goes below the. road surface.
Absolutely.
The driveway will go down to the house.
Right, yeah.
Absolutely. So,
So, by the way, I had a conversation with someone who works here. And he made the point that a lot of the people who experience ongoing flooding and more drainage and water damage from, like rain we got last week, or we're going to get tonight and tomorrow and all that. If that property was being developed today, it would have never been approved.
right.
But it was
Right.
approved when it was built.
Right.
And there's nothing you're going to do about that. I mean,
Well, but see, that's my point is if you look at the DRs, which are old, my original DR in here, the original, there's a couple of amendments to this, have to do with timeshares and stuff, but the original language says 7 feet. 7 feet above mean sea level.
Yeah.
So, which is at least 3 feet above base flood, because base flood is based off mean sea level.
Well, what you have with Ocean Pines is most of Ocean Pines is in a critical area.
Mhm.
And we are the least restrictive, regulated, critical area designation there is.
I believe that.
So the county will let you cover 100% of your buildable area on your lot.
Wow.
Now, they may require replantings, but they will let you cover your entire buildable area with impervious surface. Well, that, you can't, like Steve said, I think buffer now is like 1,000 feet from the water. You can't build Ocean Pines today.
Right.
It would, the people at Boise Cascade trying to do Ocean Pines today would all be thrown in jail.
You can't do the bulkheads anymore either.
You can't do the bulkheads. I mean, my house, I've got a picture of my house that was built before the canal was dug. And
That would be interesting
the
to
lot
see.
next to me on the right was the last solid ground going out towards the river.
That would be interesting to see.
You can't touch
But yeah,
that.
you can't do bulkheads anymore.
No.
There'd be about 100 lots in Ocean Pines.
So those are my comments. I hope that wasn't too much.
Well, I'll keep these notes. And I expect to be doing this maybe one or two more times to address people's concerns. And, but we would like to get this done, get these used ASAP.
Yeah.
your first reading that'll come up is at the next board meeting?
That's next board meeting.
Okay.
Yeah.
Great.
Anybody else have any?
Thank you for
comments?
coming.
No,
All right,
Thank you.
what we've tried to do, again, is clarify things, deal with stuff we've dealt with in the committee, keeping our mind on what we think the intent of these things are. And if we worded something wrong, let us know, but we haven't hopefully strayed too far from what our mission is to produce a set of guidelines that is usable and enforceable. And unless you'll see some of these things totally crossed out. CPI doesn't enforce some of this stuff anymore. So it's like, take it out,
Yeah.
and we've clarified things. We're starting to start needing more surveys. We're dealing with surveys of proposed houses from 1997 or
Yeah.
early 2000.
Yeah.
And we've run into situations where we have required someone to at least stake out a lot before they put a fence up. People are going, I didn't know my lot was here. I didn't know my lot went all the way over there. And it just lets us know that we are not doing anything wrong. And with the fact that Ocean Pines is now almost fully developed, maybe that didn't make any difference when the next, 12 lots next to you didn't have anything on it.
Right.
But now 5,000 square foot lots like this, we've got to be careful that people are staying where they belong.
Yeah.
Just out of curiosity, this isn't a complaint. I'm just curious. Obviously modular homes are allowed, you know, that are
Modular
modular,
homes are.
but there's a new, there's new wording in here that says we can't move an exist. I'm just curious, there was an issue with that? or-
Well, in the beginning, you could pick up a house from somewhere else and bring it into Ocean Pines. And actually, shortly after we bought our house in Teal Bay, there was a house on the corner that got picked up and taken somewhere else in Ocean Pines. But
That's
now,
interesting.
again, all the housing, all the cars, you just can't do that. So that was taken out because that's not even applicable anymore. Now modulars you can bring in, you can have cranes and all this.
Yeah,
But I don't think it's right for us to allow a whole new structure, not new, old structure brought in here, given where Ocean Pines is today.
I'm just curious.
That's what it was.
I just want to see them come across either of the entrances, the bridges,
Right.
right?
I'll bring up another thing that we struck out because it's been a no-win situation since the beginning is the old guidelines allow 3 ways to have an RV. You can have 12 48-hour periods a year, which is an annual contract to bring it in, pack it, unpack it. You can have 4 2-week periods a year where you can bring it in and actually do something, or you could have what was called a long-term parking permit. And long-term parking permits turned into permanent parking permits. That's not an option anymore. And the reason is every time we look at those things to be, you have to adequately screen an RV, which means to us, can't see it from the road, can't see it from the water. Your neighbors don't have to stare at it. It's impossible to do that with an RV. There are some 3rd-acre lots. There's some big lots here where you might be able to put one in the back and we have allowed few. But most of the time, all we get is a bunch of lip service from the people saying you can't do it because if you do boats, you can do boats, you can do boat trails. What's wrong with that? What's wrong with that? And I said, well, the problem is this is recognized as a water-oriented community, not a campground. So no, you can't do it. I said, if you have a problem, you go to the board meeting, you sign, you put your name on the agenda, or whatever, you stand up and make your public comment and say, you guys need to do something. And on my annual report the last couple of years, I have put all at the bottom that the board should look or investigate into an area in Ocean Pines where they could create an RV lot. Now, I don't know if that exists, but if it did, man, they'd fill it.
Interesting.
Yeah, the charge. Makes
They
money.
charge.
Story.
Time when Boise Cascade wanted any lot back that somebody else wanted to sell.
Yeah, I could see that. I could see that.
Yeah,
All right,
People are
good.
buying them for investment purposes.
All right, very good.
right.
Recording has started again, so it's.
Today, they never allow this area to have been developed.
I got 14 minutes.
What else do we have to
Say
cover?
thank you very much for coming.
Well, thanks for having us. I hope
This
I,
was very helpful to have.
appreciate- I hope I,
so
helped a
that we
little
didn't
bit.
have to play email tag going.
That, yeah, that
you
takes
know.
forever.
Yeah, I think it was
Yeah,
great.
so we appreciate it. We
Yeah, and I
all the
appreciate
hard
you guys'
work.
comments.
Very
I mean,
nice to meet
Looking
you, John.
for ways to, like I said, to make this more simple and more understanding and close those gaps that you're bringing up. We don't want to create these gaps, we want to close them. Okay,
All right.
all right.
Thanks
Thanks,
for
guys.
joining us. You have a good rest of your weekend.
Come back anytime.
Stay
Yeah.
calm.
Yeah, all right.
Yeah.
I'll remember that.
Okay, so
Want to do the governing document? Or are we, oh, did you do that already?
Did you
Uh,
do them?
Do we want to run through, yeah, before I go, this governance document?
which one?
I mean,
did you
do
just
the
say?
governance
The
document.
governance.
Do we want
yes,
to run
let's
through
do the
before?
governance one.
Yeah, I mean, I made some updates to it, but I don't think I got them all.
Okay.
So I got the 34 versus 33 DRs that
Yeah.
Bob pointed out. I don't have any changes for the Bs. We decided to leave C1 as is for now. C3, I'm leaving as is for now because I guess there's
Right.
work going on there.
That's it. Right.
C7, even though I put in here that per our rules, we made the change. I'm just gonna leave it as it is until you get something officially back.
Right.
C10, you notified them?
Yeah, I don't think they've met yet, but yes, I had.
You notified them, okay. C13, we're just gonna leave, oh no, C13, we're good to go. Because
They updated and said they're good.
yeah, good to go. F5 rescinded. The F,
We
Yeah,
have
number
the unnumbered one, any,
There's no.
okay,
there's no update
so
on
leave that as
It's
is.
just, I did speak to Monica and I said, my fault, that I said we would, bylaws could draft something. I said, the opinion of the committee was that it's up to budget and finance to draft whatever it is they want to say, because bylaws may not agree. And I said, I suggested what I suggested only because I was trying to get it done and taken care of real quick. And I said, that's not gonna happen now. She acknowledged that. I will go back to Monica and just make sure she remembers that this is on Doug and his committee to take care of.
M2, no changes. M4, I got highlighted in yellow because it's coming due, so it's due next month.
Do you want me?
So that you send them a note and just remind them that it's due next month. So it's not behind, but it's February 24th.
Well, wasn't there an amended version of M04 approved?
Yes. Yeah, that was the one we fought over after M01 passed, yes,
That's right.
Put the word-
that's done.
So I-
M04 is
Put the
done,
door open.
So I need to get the date for that.
last board meeting.
Last board meeting? That's right. You're right. I'm sorry.
Yeah.
Okay. I'll update that.
December 4th.
So what we say, do I need to remind?
Nope.
or not?
No,
No,
no, you're good. M6,
That's the
That's
one we
the
were gonna
election.
go over.
that's the one you're gonna go over and potentially send some feedback back,
Right.
right? That's the idea there. M9, no change there. And that's all I had. Anybody have any other changes to that?
No,
On N06, I would at least suggest, let's see if it's on the board's agenda for first reading for next week's meeting. I don't know what it is.
M6.
And the election
Election.
The
committee
elections one.
or election resolution,
Let me-
before you send something back to them, I want to see whether it's on the agenda for a first reading. You may have a little bit more time to fiddle with it. That's
Okay,
just my
so
thought.
I also,
No one
for
cares.
the elections, before we start really looking at it, this is what Tom Piatti, the election chair, had sent to me in the body of the email, not in the document part. that attachment A9 is being modified to essentially provide the option of an observable count by an independent contractor. In experience, finding a contractor that provides a service is a challenge besides being costly. Also, we will recommend online voting be implemented in 2024 as was done in 2022. Online voting is an electronic process that cannot be observed. You must trust the result. Therefore, we believe it to be reasonable to trust the ballot separation, count, and adjudication by an independent contractor. Number two, he says 8.9C is being modified in that adjudication is visually performed by humans. Three, he said attachment D4D is reversing this sentence. Viewing and retaining a paper ballot is preferred.
Well, that was Jim's point. Yeah.
So then finally, we will not be seeking a change to the bylaws concerning the election time frame and annual meeting of the members. And then he said, let us know if we have any additional information or questions for him.
But all that stuff wasn't marked up in that document, was
It
it?
wasn't.
No.
The document
No.
had just two markups that were different issues.
Because the whole online voting thing, it seems to me there would be quite a bit more in there associated with.
It's a separate attachment. Online voting is
It had all the attachments.
4 or 3, I can't remember which.
But there was very little red line in that document.
Oh,
So 06 I have here. I don't have a, let me see.
That's red line.
Attachment D has that one little red line that Jim pointed out about a paper ballot invalidating an online vote. And I think,
when you sent, Laura, when you sent M06 out to the committee, did you include Tom's comments?
Which one?
When you sent M06 to the committee for today's consideration, did you include Tom's comments that you just said on the screen?
I don't know if I added that as a separate document when I sent all that stuff out to you
Yeah,
again.
Yeah, you want to send that to.
So, yeah,
Yeah, I don't think.
I mean, I still, it's all gonna fit under the same.
right.
Just,
I'm looking for-
yeah, the only other red lines, significant red lines are, what is this section? It's under receipt of ballots by contractor. There's a few, no, under issues requiring a duplicate, no, under counting ballots. It's under the paragraph to counting ballots is really the only other red lines. So I agree with Jim. There's no way this was a comprehensive edit of this document to take into account all the.
And what he sent to me was not a red line copy that I sent to you, which is what I have up on the screen now. This is what he sent to me. This is the proposed, but it's not like a red line copy
Well,
of
the
it.
one you attached to the email was redlined.
Was it?
Mm-hmm. But you have to go down a ways to find it.
I just think his other comment should be included as well. That's
And I hate to do this to you, but I'm gonna pull
Oh,
out.
there's
here about 6 minutes.
Okay. Peter's in there. You guys just think they're gonna find out some of these.
There's only a handful of red
Here we
lines
go.
that don't seem
So
to.
here's the beginning of the process.
Issues.
Um. So it looks like he's got the comments next to the red lines there that they deleted X part of it. You know, in these sections,
Yeah, that's the most extensive red lines in the whole document right there.
yeah.
That's good. That's relates to one of the email things about being hard to find a contractor that can allow an observable count. Basically says, we'll do it if we can.
Go back.
it's being done up in Washington.
Yeah. 10.
I got to go. I'm
I
sorry.
think we should,
Do you want to report back, or do we have specific questions for him?
Well, I
Do
don't,
we think we need to get back to them before it goes
that's what I'm saying. I don't think you should do anything
until
with the
after?
committee until we know whether or not this is on the agenda for first reading.
Okay,
If it's not on the agenda for the first reading, you've got a little bit more time. But if it is, then you know you've got, we basically, the committee might have to meet sooner than what we're scheduled to meet
okay.
in order to get it done. But I would not send him any comments right now.
I agree with that because it's gonna take a little bit to read
Yeah.
through that. And
Yeah, and I'm not sure that they have, and both you and Jim have pointed out, it's been as comprehensive as it should have been. I mean, maybe it is, I don't know, but I'm just saying.
I spent most of my prep for this one on this.
So I don't need to do anything with this then? other
No, the only
than-
thing I'm suggesting is you should make sure that Tom's additional comments get sent to all of
Other
us as
than,
well.
okay, all right. Because I put them on my own Word document, so I can, send it. I can't remember if I did that or not.
Jim, did you write down any notes about anything specific with regard to M06 that you could share?
Not other than what I previously said. There's a lack of evidence of a needed comprehensive review of that document. In particular, emphasis on a vendor or contractor who's going to do going to do the counting of the ballots as opposed to the elections committee. The only thing in that document is relevant is attachment A, and attachment A is written specifically for counting by the elections committee. And what has been done is to simply graft on there or Band-Aid on there a statement that can be delegated to a remote, or not a remote, again, a contractor other than the elections committee. Is that adequate? I personally don't think it is. But that's my opinion. There can be others who can say, well, that's good enough. But I think the fact is, and again, this is my observation, my perception, my look at it. What happened in 2023 election is what we went on was the basis of the proposal from the contractor, and then the contract essentially just accepted the proposal. We're stuck with that as the resolution reads right now, with the same thing going forward. That's my view of the situation. Is that adequate? I don't think it is.
Right, so I will send out the comments to everybody that Tom had put in the body of the email. Do I need to respond back to him other than to find out if he's planning on having, or if it's been approved to be on the January agenda for the directors?
No, I think, I don't think you have to say anything to them.
Okay, so I,
We'll
and when
we'll
we
get
see
there.
it,
We'll see the agenda for the next board meeting,
right,
middle to end of next week.
okay,
So if it's on there, this committee knows
okay.
you're on a tight time frame. If it's not on there, you have a little bit more time to
If it
develop
was
some
a
thoughts.
first reading on January, likely to do it a second reading in February,
I would
correct?
assume that's what they would go
Right.
for.
So that we might need to throw in an extra meeting.
Yes, that would be my assumption.
But I do not need to reach out to him at this point, unless we have questions after we meet to discuss it again,
Yeah.
Okay. All right, is there,
Laura,
uh-huh,
with hesitancy, I'm going to say this. Steve, the June meeting, the interchanges between yourself and Doug Parks on this topic,
Right,
had this approach of the two committees, meaning bylaws and resolutions. bylaws and resolutions and elections
Right.
getting together and coming to conclusions of what to do with the resolution, make it a combined effort.
Yeah.
Of coming up with a new M06. That was the complete fill in, as far as I'm concerned, of that discussion. I personally do not like that kind of approach.
Yeah.
The resolution is one that the elections committee has to manage and bring about the elections process, not the bylaws and resolutions committee. But that, I think what we are dealing with here now is Tom Piatti's coming to the bylaws and resolutions for our agreement, essentially. And then from there, go to the board for a first reading. You know, obviously I am reading into things. I know that. But I don't see I don't see waiting for finding out whether it's going to be a first reading. I mean, that's whether it's going to be on the agenda.
Okay, that's fine. I mean, if Laura, I understand what you're saying. I'm trying to recreate my thought process at the time, but what I was really trying to do was trying to find a way to accelerate whatever the elections committee was going to do, on the hope that we would get something that would review M06 sooner than we've now gotten it. I mean, that would, but I understand. I have no problem with letting them take the lead and then we get it. That's fine. That's okay.
Okay.
Look, if Laura wants to send an email to Tom thanking him for his, sending this over to us and his additional comments, and the committee will consider, what's been provided, as soon as possible or forthwith or whatever term you want to use, that's fine. I don't care. I'm not sure at this point it makes a whole lot of difference because the board's going to meet next week anyway. But if it buys us a couple of extra days, that's fine. That's fine. I don't have a problem with that. But I'm assuming that this is the completed work of the elections committee. I don't know that I see them getting the second bite of the apple unless they want to take it. But that's just going to chew up more time. Go ahead.
Well, I agree with that. And I understand or recognize that you've apparently not had an opportunity to see or haven't had a chance. I can understand that you've had a pretty busy schedule recently to see the red line copy that has come to the committee. That
Right.
red line copy could be reviewed. Unfortunately, the guidelines discussion has been the balance of the meeting. That red line copy proposal could be reviewed in about 10 minutes. There's no more than about 4 or 5 red lines in the document. One of them has been discussed to a degree, and that's the what comes first, the vote that's already recorded electronically or a paper ballot that happens to come in also. Beyond that, there's really nothing much of any consequence in there. I think Augie made reference to the one about witnessing the count. Well, we've got it in there. Well, maybe we will, maybe we won't be able to. That's you kind of pass right by that and forget it. So there's nothing in that red line that takes any length of time to review.
Okay, I can see the point, but the question that then comes up at that time is, are you saying to us, Jim, that the bylaws and resolutions committee can only address those issues that the elections committee addressed in its red line, or that the bylaws and resolutions committee has the authority to make or suggest additional changes prior to board consideration. But let's be honest.
Okay. I will answer it this way. The Bylaws and Resolutions Committee should comment on the red line.
And
The Bylaws and Resolutions Committee should not be attempting to rewrite provisions in the resolution that it believes should be rewritten. Now, I'll modify that by saying if you see something that conflicts with the governing documents, yes, that needs to be commented on. But the main comment, in addition to the comment on the red lines, is not necessarily that I made, is not necessarily for the elections committee. It is for the board of directors. And frankly, my comment was directed to you as a director. Now, whether the committee wants to take it up as something to bring to your attention, that's another point. You know, the committee's the committee. I'm not on the committee anymore. But it you know, I had to go back and watch the entire interchange between you and Doug at the June meeting, and say that's got to be commented on. It's got to be commented on that the only reference that we make in M06 to a contractor counting of mail-in ballots, the only reference we make is the committee can delegate it to the contractor, and that is in an attachment that is solely intended for election committee count of the ballots. I think that is very important to recognize that. As far as the markup, I think that the elections committee bylaws committee is responsible for reviewing the markup, but going beyond that, unless there is some specific reason to do that, I don't see that the committee should be doing that.
well, that's fine. I mean, I understand that. I will, you know, I think I'm correct that when this came up in June, I prefaced my comments by saying that due to the time frame that we were now facing, you know, we need to, and the fact that we had already agreed to a contract with a company based in Washington, you know, we don't have much choice but then to accept those changes that the committee was then proffering at that time. I'm not entirely sure where we are with the contract situation coming up for the next election. I'm assuming, although I don't really know, that the contract from last year was only a one-year contract, but maybe I may be wrong about that. I'm not sure. So I mean, the notion of delegating the authority to count to the contractor was just, we were stuck. What else were we going to do? We didn't have any choice. And that's why, in part, because I remember there were comments about the timeframes and the conflict with the bylaws. I think there was some issue that we talked about dealing with the search committee, which the board has never taken up, although I've sent this to the board back in October. You know, there are other issues relating to M06, the attachments to M06, and the bylaws as they exist. But that's why I think it's important that Laura include Tom's other editorial comments that are not within the framework of M06 that he sent as part of his email. But you know, the reality is, if the bylaws committee has suggestions relating to M06, we're only gonna get one bite of the apple. I mean, if you want the board to change something, you're gonna have to say, or the committee's gonna have to say what it is they want that change. And we would have to, or I would have to be prepared to offer an amendment to whatever is gonna come up at the time of the second reading. You know, with all due respect, calling it to their attention is not going to solve the problem unless there's something in writing that says this is what needs to be done after we call it to their attention.
Yeah, Steve, as M06 is written right now, and the red lines that in attachment A of M06 are essentially unimportant with regard to the election process. But as M06 is written today, are you satisfied that M06 adequately covers the circumstances of a contractor counting the ballots?
It was all, in all honesty, Jim, I'd have to go back and look at it. I'll stand by what I said just a little while ago. We made the changes relating to the fact that we changed contractors and we had no time to do any other examination. My recollection is that the contractor was obligated to, in essence, provide to the elections committee and anyone else who wanted to watch live streaming video of what they were doing when the ballots were being counted. Now, keep in mind, there was no online voting last year. And then I'll carry it a step further. If I remember correctly, at the time the ballots were being counted and the video streaming began, they already had a tally sheet of a number of votes already counted. Now that never came up in June because the tally actually took place in August. But I think the feeling at the time was we signed the contract, and then we changed M06 to conform with the contract. We probably should have done it the other way, but I mean we were stuck. So whether or not I think it works, I mean part of that depends on if we're going to use the same contractor. I don't even know that answer. So you know. I'm not sure that there's even been a request for proposal put out for someone to respond. Are we going to change contractors? Somebody put out an RFP? I don't know. I certainly haven't seen one.
Steve, let me be a little more. I'll try to be a little bit more clear in what I'm trying. The point I'm trying to make, or what I'm trying to express.
Okay.
Attachment A is written for and is solely intended to apply. And when I say that, I'm talking about going back to the origin of M06. I'm going back 15 years now, plus or minus. Attachment A is entirely oriented toward, originally was entirely oriented toward the election committee doing the ballot count.
Right.
What was done in June of last year, up against the situation that we were going to a contractor count, what was done to attachment A, again, written only for election committee count, what was done to election attachment A is to add in there the count could be delegated to a vendor, to a contractor. There was also a provision put in there to clarify that, okay, if it's done at a contractor, we're going to be able to watch the the count process. Well, that turned out to be, although in the contract, didn't happen and was never going to happen. But those two changes were all that was made to accommodate the fact that we were going not to the elections committee to count, but to a vendor. Is M06, if we're going to do a vendor count in the future, this year or any other time in the future, is M06 as written with those changes only adequate for contractor count contracts?
Well, Jim, why does it make a difference whether they put the authorization for using a contractor in attachment A rather than in the body of M06? They're both passed by the board. And if it says you can do it in attachment A, then you can do it.
Well, okay, but my point is that the attachment A has processes applicable only to the elections committee doing the count. It in no manner addresses what the processes or the controls of the processes or any other characteristic of a contractor election process. It doesn't address any of that.
So you're saying it's not specific enough about what the contractor has to do?
I'm at least questioning that.
Mm-hmm.
To me, you need to have more information of what you are expecting of a contractor. You need to have something in there that the contractor can at least look at and understand is what's in your proposal. Something that we put in a proposal needs to have some kind of consistent foundation to it, it would seem to me.
Mm-hmm.
Well, I guess, Jim, the short answer to your question from my point of view is, as I said before, I haven't seen the red line recommendation of the elections committee. I'll go back and look at that. But if at this point, if bylaws and resolutions doesn't make any additional recommendations or doesn't suggest changes to what the elections committee is proposing or does not identify a particular problem, I would look at it simply as a board member and make a decision. I'm here as the liaison. If the bylaws resolutions committee doesn't suggest any particular problem areas, doesn't suggest any particular changes, I'm not sure what you're asking me. At that point, I'm free to make my own determination.
Okay, well, what I'm specifically asking of you is to look at the red line and then go back to your discussion with Doug at the June meeting and see if you're satisfied.
Okay.
That's a specific, now, again, that's to you personally. Now, to a certain extent, the committee members may not have much knowledge of what took place at that June meeting.
Well, look, I have no problem doing that. Okay. What I will say to you, however, is, and I'm sure you're probably aware of this, the consideration of N06 at the June meeting followed by a month or maybe 2 months, the larger discussion about the contractor and what services are going to be provided and why the committee accepted that contractor as opposed to a different contractor, and whether or not this is even a workable solution. And faced with the time, as I said before, faced with the time frame we had, we went with what was done, which seemed to be the best method available. Now, I don't know. I'll look at what was said in June, but I would not take it as written in stone, since both, I'm speaking for Doug to some degree and for Rick as well, we're all sort of flying by the seat of our pants at that point. And my concern was that, as you pointed out initially, that what we voted on in June was nothing more than a Band-Aid to address the issues of the contract that we agreed to a month or two before that. And that there were other issues that needed to be addressed as well.
Well, the only issue that was addressed in the contract, it wasn't really an issue addressed in the contract. It was an issue addressed in the resolution, where people were concerned that there was not going to be transparency like transparency existed with the elections committee count. That was the real focus, I believe. Is this issue of transparency to be able to witness the count like we had been doing in more recent years.
Because the contractor was located out in the state of Washington.
Yeah, okay.
I mean, I get that. And that, I mean, without saying it, that was the issue that everybody was trying to find a way to address. We awarded the contract. We are now stuck with whatever the contractor was going to do, even if it was in complete violation of our own bylaws. I mean, and the resolutions. So, I mean, this goes back to putting the cart before the horse. I had nothing to do with that. I mean, at that point, I was just trying to back and fill.
Okay.
But let me carry it. I mean, for instance, Tom's for lack of a better term, editorial comments to Laura is like, we're not recommending any changes in the annual meeting or in the time frame between cutting off the election and when the count takes place. I think that's what he said. But we had to have a special board meeting to make those changes. I mean, I think I understand what you're saying to me. I think I do. And my point is, based upon what happened last year, there might be other issues that we need to address. Whether or not the elections committee or the contractor handles the vote count is one important issue to consider. But I'm not sure that we shouldn't include, because this came up during the special board meeting, I'm not sure that we shouldn't include language that gives the board the authority to adjust the time frames based upon the inadequacies of this contractor provided. Remember, we ran 3 weeks. We lost 3 weeks in time frame between the time the ballots were sent out and the time that most everyone got their ballots. And no one bothered to check with the contractor as to why this was going on. It turned out he was overworked. He had too many other elections going on.
Well, Steve, to see what you were up against in that delay was the bylaws provision of the validation of the election must be at the annual meeting, and continuing on the schedule that that would call for was seen to seriously impact the number of ballots that could be received. That's different than what Piatti was addressing, and that is the cutoff for eligibility to be sent a voter package. The special meeting had to address was the receipt of ballots because of a delay.
Well,
Piatti raised in his report the concern that we had such a close cutoff date to the annual meeting that there was insufficient time to move packages and ballots back and forth across the country. There are two different things, completely two different issues. Now we're getting nowhere, I think, in a lot of discussion and
I'm not sure we have a quorum.
and we kind of need to, I'm going to bring my part to a conclusion by saying this. I do not agree that the resolution red lines as written at all adequately address when a vendor or contractor is the party that counts the votes. And that's my suggestion to the committee that be looked at and a determination, the committee make a determination if we really covered adequately in M06, what is going to go on when a vendor does the count. We cover that if the election committee does it. Do we have-
Jim, since it says delegate, wouldn't that imply that the vendor has to do everything the committee has to do? So in other words, the rules for the committee apply to their delegee, because that's what a delegee is. They only act in the authority of the delegators. Therefore, the contractor must do everything the committee must do.
Okay, I'm not going to disagree with that, but then you have to go back and look at attachment A and see if you can read attachment A to be adequate in that regard. And I don't think you can.
Okay, Jim, I mean,
Or consistent, maybe.
Augie is correct. We're now absent a quorum. So, I mean, let me just make, here's my view. I will take whatever the committee gives me and raise it as an issue when this matter comes up before the board, particularly for second reading. And if the committee wants to give me suggested language to address those particular problems, that's fine. I'll take that, and I'll take that to the board. But to me, in my mind, if there are additional issues relating to N06 that need to be addressed, I think it's incumbent upon this committee to take those up, because it's not going to go back to the elections committee.
It's a committee.
And if that's going to affect the process of this next election, then it should be addressed. But that's me. If the committee doesn't give it to us, that's fine. Give it to me. That's fine also.
Well, okay, but let's be a little bit realistic though, Steve. Going through the remainder of the of M06, there's information in there about there was an approved amendment regarding requesting a recount. That's new material. Now, when I say new material, it's new material in the resolution. It's not new material to be considered. It's not a proposal now. It's in the resolution. Other than that, attachment A for a committee count has been there essentially as is. There's been some changes, but not significant. The only real significant change was changing the committee count from a closed meeting to an open meeting, which is transparency was used as the reason, but really the closed meeting, open meeting act provisions of the HOA Act really applied. Attachment A is essentially there and has been there. Attachment B is essentially there and has been there. Attachment C has been there, as is with some change for years. Attachment D is new because that's online voting. There's not a heck of a lot for this committee to go back through and really scrutinize, other than is vendor count adequately considered in the resolution, and the red lines, which should take no more than about 15 minutes to review.
Well, that I respect your opinion. I would leave it up to the committee to determine.
I agree. I agree, but let's not make, I'm saying, no, I'm not going to make, I don't want to see a big issue made out of the bylaws and resolutions, sitting down and spending a lot of time going line by line through M06. Now, for me, I think at this point, I'm ready to say that I would recommend to the committee, suggest to the committee, I'm not going to recommend anything. Suggest to the committee, you do the red line review and send it to Piatti. What you want to say, if anything, about, well, is this adequate for vendor count? Are there adequate provisions in there? Well, that's something you can discuss, and I think Augie has his own view to that, and others may have their own view to that too, as well, whether it is or isn't. That is an issue to be considered. But the immediate issue is the red line, and do you want to feed back to Piatti anything about the adequacy of coverage of vendor count? Those are the two, the red line and that issue. The issue of feedback on the adequacy. The committee wants to touch that or not touch that, that's, I'm not involved.
To the committee.
Well, let me interject and say that at this point, the committee cannot make a decision
No, course.
officially because we do not have quorum right now. Keith had to leave at 3:00 for another meeting. Pam is not here. We need to have at least 3 of our 4 committee members present to be able to be considered in compliance. So right now, it's just Augie and I don't believe without, now, I don't know if we are allowed to use email like the directors do, that if there's no discussion and no objection, you can actually vote, on something like that. Is that something that we can put together as an email and finish discussing, or it has to wait until the February meeting, for us to officially write up anything to send to, in my opinion, the elections company saying, look at such and such. What your Augie as a felt myself.
I mean, at most, I would send around an email saying, does everyone agree to this email? Say, make sure that this adequately covers using a vendor. I mean, I tend to think it's better just to have the rules the same for the vendor as the committee itself, and make sure the contract complies with that, rather than having a separate set of rules. But I don't know, if you send an email around, and you'll probably get everyone to say it looks fine. If it, like, make sure that the resolution is sufficient to allow a vendor count. Goes into enough detail on that or whatever. I don't know.
And Jim, I think, I'm trying to recall here. The emails that you've sent prior to today's meeting, they addressed more of the ARC questions and stuff, correct?
Yeah, I would agree with that, yeah.
Feel that you want to put together in writing a quick email to me and or the whole committee with these thoughts, then I will send out an official committee email to my fellow committee members, and we can agree to whether or not we need to send some kind of an email to chairperson of elections saying the only concern at this time that we have is this point. Is that what we're,
Say the only concern. No one's really had a chance to review it, I think.
Right.
So.
All right, so the only other option I would have would be to let them know that we're not able to fully do this because we did not have all of our committee members present, and that we will be moving it to our February meeting for full discussion on the February 9th, I believe it is, and the directors meeting in February is the week after that.
Well,
On the 17th.
my suggestion would be not to get pinned down to the February meeting. If Piatti says, I need something back in 2 weeks, then the committee might want to meet sooner.
Yeah.
But it may be sufficient to just tell him that the committee has not yet been able to
Fully discuss.
to consider and deliberate on what the elections committee has provided,
All right, so I can do that much, I guess.
and see what his response is. I mean, if he
If he
if
needs
he
it.
said
for-
he needs it sooner,
Then we'll-
you should tell him, let me know that.
Sounds good.
Getting close to an election.
Yeah. Well, the comprehensive review everyone envisions.
Okay. So
Yeah,
just remind
Yeah, that's-
Augie and everybody else, our next meeting is on the 9th, February 9th from 1 to 3. unless we have to put in something earlier than that. Do you have any other comments before we go?
Jim.
Jim?
No, what I was gonna say, it's not important. It just adds to the discussion, that's all.
We've got to get back to getting this committee to stick to our 1 to 3 timeline.
Well, I think
Our
that meeting
meetings
ended
end up
at 3.
going way longer, so,
Yeah, absence of a quorum, technically.
you know.
Yes.
So, all right, well, I thank you all very much for coming tonight. Happy New Year. I'll give an update later once I get everything together, okay?
Okay.
All right,
All right,
thank
Take care.
Thank you.
See you later.